Welcome back. I'm glad you're still with us here on Morning at NTV. Time now for the Kickstarter. I'll be introducing my guest very shortly as we begin to look into what it means, especially with regard to developments over the last 72 hours or so. And that, if you have been watching right from the beginning, today is the denial of bail to retired Colonel Dr. Kizza Besigye and his AD, Obed Lutale, on a Friday. That particular development will form the prong of our discussion as we look into the role of the judiciary in safeguarding and protecting the Constitution. We shall also ask the question or questions relating to, is Uganda's politics being judicialized? Yeah, that is one aspect that we must pay attention to. I'll be introducing my guest, like I said, very shortly, but our preamble today, fear of politicizing the court has always been the primary argument against the performance of Uganda's justice system, and in particular the process of appointing justices of the Supreme Court. And the recent court decision on Kizza Besigye and Lutale's bail application is retabling that argument and for political responses against the opposition figure. Are these sentiments of the body politic permeating the judicial system? Well, we shall find out. This is illustrative of the importance of a court as a political arena, but also the fragile institutionalization of judicial independence in courts. I'm joined on set by Enoch Barata. Enoch Barata is from Birungi Barata and Company Associates. He's with us this morning for much needed perspective. Many thanks for joining us, Mr. Barata.
Thank you very much. Thank you for having me here. And good morning to our viewers as well.
Great. We are honored to have you on board. The very first time on Morning at NTV, I guess?
Yes, the first time on Morning at NTV.
You're most welcome.
Yes.
Now, this discussion comes on the backdrop of the denial of bail to retired Colonel Dr. Kizza Besigye and his AD, Obed Lutale, by the Justice Kania on Friday, something that has lawyers red-faced and up in arms on what they say were grounds that were not of sound law. I do not know whether we are not permitted to discuss this particular issue as is, or we can contextualize it.
Well, I suppose we can contextualize it since we are already here and since you are anyway asking me about it. I suppose we can contextualize it and have a, perhaps not the detail of the case, but we can maybe look at the general subject or the general gist of the subject.
What does this augur for the judicial processes in the country when, for example, a person meets the threshold for bail but is not granted that particular bail as a cornerstone for justice?
First of all, what we have to understand is bail is not mandatory. Bail is discretionary, and that is why somebody has to apply for it to the court to be granted bail. So it is not guaranteed, and it is discretionary. Discretion means that the trial officer, the judge or magistrate, looks at the facts and circumstances on a case-by-case basis. There is no generalized standard that once you do X, Y, and Z, even when those requirements are put in place, have sureties, have a fixed place of abode, etc. Even when you have those, on a case-by-case basis, a judicial officer, on assessing the circumstances of each case, might deny you bail for one reason or the other. We have seen this in multiple cases. In my view, bail is not a political issue. Bail is a matter of delivery of justice, and we must understand that in delivery of justice there are always two sides, and so it is a question of balancing those two sides and balancing the interests of justice. So it is not really a political issue, as we can see. There are multiple bail applications on a daily. If you go to any court in the afternoon, any of these chief magistrates courts, even magistrates courts, even grade ones, you will find every afternoon there are bail applications, even in the mornings. So this is not a political issue. It is a matter of delivery of justice, and I believe that the independence of the judiciary lies in that discretion exactly, for them to make those decisions as they see fit.
Okay. I love the fact that you've been very articulate on the aspect of it being discretionary and also down to circumstances. Sometimes we can readily say the circumstances of Dr. Besigye and Obed Lutale may warrant speculation that they could influence investigations. But I want to ask the question, at what point shouldn't, I don't know even how to describe, how to phrase this one in particular, because I seem to be having a lot in my mind regarding that particular issue. When a judge or a judicial officer says that this particular case or charges against these individuals are one of the grave ones, or the gravest for that matter, and might not require that they operate freely out there. I do not know whether this is speculation or this is the individual judgment that any one judicial officer or a judge is allowed in the discretionary nature of granting of bail. Take me through that.
That is exactly it. That is where the discretion lies. I mean, we have seen other cases where bail has been denied, and if without prejudice, I don't want also to discuss that too much. But there's a case that is widely covered in the papers these days, the Katanga trial.
The Katanga trial, yeah. And
you have seen bail denied several times, even when investigations are complete and the trial is going on quite okay. Even when we can see that a few other people are on bail and haven't had any problems with it. So these are discretionary matters, and we cannot begin to second guess our judicial officers. The only way we second guess judicial officers and test their theories and test their decisions is by referring them to other judicial officers, usually on appeal, and that usually is the process. So it is that discretion that delivers justice. There is no straight fit, and there is no dictating how one should deal with a bail application.
Okay. Allow us welcome Ezra Rashande on board. Many thanks for making it and joining us for this discussion this morning. And we are generally looking at the judiciary's role in safeguarding and protecting the Constitution. This comes on the backdrop of the ruling on Friday that saw retired Colonel Dr. Kiza Besigye and his AD Obed Lutale denied bail despite meeting the standard threshold for the same. But as if the words of counsel Enoch Barata are anything to go by, it was well within the leverage of the judge to deny bail on that matter that she insisted is valid.
Good morning, viewers, and good morning, Chris and my colleague, Counsel Barata. It's a pleasure to be here this morning, and the topic brought to us today, it is a very sensitive topic.
Yep.
Yeah, to both the population and all organs of the government. I would want to first ask to appreciate that Uganda is facing a similar trajectory. The judiciary, instead of acting as a check to the executive, is increasingly being used to silence dissent. And that we have seen where the advocates who come up to speak against injustices find themselves being harassed, threatened, and all sorts of manners that are happening to their lives. The case of Dr. Kizza Besigye, personally Dr. Kizza Besigye, whose resilience as an opposition leader of Uganda for a very long time, for like 20 years and above, has become a visible repression, a visible representation of state repression. His repeated, his repeated illegal arrests, detention, kidnaps, abduction that we have seen happening in Kenya reflect government that prioritizes suppression over good governance. We have seen that before happening to Dr. Paulo Kawanga, Semogere. Beyond the judiciary, executive and legislature work in tandem to entrench authoritarianism. We have seen that. We have seen Parliament rubber stamping the laws that tighten the regime's grip on power. And all that, for example, we have seen term limits, the amendment of term limits, age limits, and other laws curtailing freedom. And this has been done through Parliament, and after Parliament, even when you go to the courtroom to challenge this, it is upheld. In other words, we have seen politics take its course in the courtroom, as per now, and that's where we have reached.
Thank you very much for that background, but let me ask a very direct question with regard to application of the law, maybe. Do you believe in the, I don't know whether in legalese, what you could call it, but let me speak like a journalist, the narrative of discretion, that judgment can be made based on the circumstances of any one person as a suspect, and in this case, Kizza Besigye being one who is powerful enough to influence investigations in the event that he is granted bail and is out.
You see,
remand.
The discretion, the court has the discretion to give or to deny bail, but also there are other principles that come in line with the discretion of court. One, there is presumption of innocence.
Okay.
Two, every accused person has a right to apply for bail. Which has taken place.
That is right.
But the presumption of innocence, which is under Article 28 of the Constitution, is that every person or every accused, or every person who has been accused of any offense, it is the prosecution to prove whether he is guilty. And Dr. Kizza Besigye has been remanded for a long time. Even a time frame has to be put in consideration for someone to look at discretion. As much as you have discretion, have you considered the freedom of that particular person or the accused or the applicant who is applying for bail? Definitely, when someone applies and the prosecution takes place and comes up with the requirements, for example, the fixed place of abode, and then substantial sureties, and introduction of LC1 letters, and all that is submitted, and you're going to give a ruling and you say all the requirements have been met, definitely you all expect that such a person, he or she, has to regain his freedom. Even other circumstances that become alongside that, they are fulfilled, where he's at the advanced age. Advanced age in the law starts from 60. Kiza Besije and Mr. Rtaro, they are above 60. One is 65, another one is 68. So when you look through this, it was not a judicious decision, it was a political decision. And that's why I come and make it clear that from the ruling that we saw, it did not consider, there was no much legalities. It was sidelined on the political side. It was sidelined from judiciary or from the legal aspect into political aspect.
The politics
yes.
of the case.
Yes.
Let me talk about the politics of the case, and this is a question to Counsel Barata. The President has often spoken about why he doesn't want bail to be granted to certain individuals, and I'm sure he's one gentleman who wouldn't want Kiza Besije to be granted bail, no doubt. We also have a case where the Justice Kania is in acting capacity. There are those who are saying if you rule or dispense justice in a manner that might rub the chief of the executive the wrong way, then you might not go beyond the acting capacity. This is the politics of this particular case. I don't know whether you agree that justices, judges, and magistrates across the country have this blanket of the President's statement hanging over them in more sinister fashion than the sword of Damocles.
I don't agree with any of those statements made. I think we must understand several things. The biggest political intimidation of our judiciary has come from our opposition. It has come from our politicians. By the way, both opposition and non-opposition, it has come from our politicians. And as you can see, somebody trying to argue a political case in court, trying to make a case for somebody in court in a political manner. And that is where you go wrong. Court is court, and we argue the law in court. And it is unfair and disingenuous, really, for anybody to try and say court should have made this decision instead of the other. That is for court. That is why court is there. It makes those decisions.
That's right.
It is not correct to suggest. In fact, the only time President Museveni mentioned this issue of Dr. Besije was during the period when the argument was about the court martial. He said, why don't we ask ourselves, why don't you say, let's present him to court and make the arguments there? That was his statement. He said, let's go to court and present him there.
On Kiza Besije as an individual, he has said that once, but he has been very consistent about bail generally.
Yes, he has been very consistent about bail, and he is not alone in that consistency, because even our communities, this is the bigger argument they have. The bigger complaint we get in the community is that we had somebody arrested, he was caught red-handed doing X, Y, and Z, stealing or doing what, or he murdered somebody, and the next day we saw him back in the village. These are consistent concerns. But we must balance between, yes, those concerns and the judiciary. And on some occasions, people are granted bail. On some occasions, they are not granted bail. As I have just given you an example of an ongoing trial, where, so when you talk about period of remand, etc., completion of investigations, there are numerous cases, and those are some that I'm pointing out only because they are the ones that are quickly referenced in the public domain. Judges are appointed. You must understand how judges are appointed, and we must disabuse ourselves of this of this thing of you know, they are all fearing the president and etc. No, that is not correct. Judges are appointed by the president on recommendation of the Judicial Service Commission. So the appointments come from the Judicial Service Commission. They go to the president. The president then appoints and sends them to Parliament, and Parliament approves those appointments. So there is no such thing as a cloud hanging over. Just on Friday, it is because people concentrate too much on politics. And we are talking about whether the judiciary is safeguarding constitutionalism. On Friday, there is a very big land rights case that was determined in the Constitutional Court, and nobody has picked up on it. Very, very big land rights case against the Attorney General and UNRA regarding land compensations. That is constitutionalism. That is protection of property rights. But nobody talks about it. So the biggest politicization of our judiciary has been an attempt to make a political case in court. A political case is not made in court. A political case is made to the electorate. And that is where our people get it wrong. A political case must be made before the electorate. If you expect, you are asking court, what I see most commonly, and I even suggest my land friend is doing exactly that, is to suggest that the court should leave the seat of justice and descend into the arena of politics and take sides somewhere. The court is not going to do that and should not do that. And if we look at our history, you will find that the court is exactly safeguarding against that. And it is a balance. Even these checks and balances that we talk about between the three arms of government, they are balances. They are checks and balances. Those words are not absolute. It is checking and balancing to avoid excesses. Only to avoid excesses, but not to interfere or stop the other one.
I love your employ of the phrase avoid excesses. I do not know whether the judges, not that allowed or not allowed. In this case, what I deduct from your reasoning is that a judge or a judicial officer can go the entire 9 yards in determining a case. Not necessarily when people expect, for example, if facts are presented to the threshold of 5, 6, they can decide to use the entire threshold in order to determine this particular case. But we have a precedent that was set, and precedents are things that judges use very often when it comes to coming up with the decisions that they do. The incarceration and subsequent grant of bail to the Rwenzururu king, and the conditions that were put on his movement within Kampala and Wakiso and surrounding areas. This could be achieved on Besigye as it was achieved on the Rwenzururu king. Why wouldn't, for example, a judicial officer act on such a precedent in order to disabuse the notion that the case could be very political?
Of course, I saw that argument being made. I think in your paper. I don't remember by who, but that is to fail to understand again the point. The point is that there is no straitjacket for bail.
Okay.
Bail is determined on a case-by-case basis. There is a standard framework, yes, but there is no straitjacket application. One case's application does not apply to another one. Though you may consider, in general terms, the same parameters, but each case is determined on its own facts. So you can't say this should have been treated this way or this should have been treated the other way. That is to misinform the public. That is to misadvise the public. And of course, we must be careful as lawyers to not misadvise the public, to argue our cases in what they call the court of public opinion. But this public opinion is not versed with the technicalities of
Mr. Rashando.
Yes.
The Honorable Justice Kania is a legal and regulatory professional with more than 22 years of experience.
But by the way, it may not be wise
to discuss her competence.
The judicial officer.
That is right.
I think you want to discuss the principles of law.
We can discuss principles of law, but
yes.
but not the personality.
One of the problems we're having is people trying
I wasn't going to delve into her competence, yes. Absolutely not. But I was just going to ask Mr. Rashande the question, why would you question, for example, a judge's decision when she has worked within the threshold of the law and she has exercised maybe the extreme of it and not what would have fallen within what you're comfortable with?
Yeah, thank you, Chris. I think I've been very articulate from the start. But before discussing the question that you have stated, I would like also to talk about what my colleague, Councillor Barata, what he stated, that we shouldn't even be questioning the decision of a senior judge. We have seen this before, and maybe we have learned from the regime. We have learned from the regime apparatus.
Could you be more specific?
Of recent, we saw the president of this country, after the Supreme Court giving its ruling, and he stated that judges do not own this country. In other words, he showed that where there is power, where the Supreme Court stops, on top there is another what? Supreme Court.
Another power.
Another power, to make it clear. And I'm so surprised. He's an NRM lawyer, as stated, and he's disagreeing with his boss. So I don't know how you're going to...
I don't know about that.
This is what I saw.
He's practicing with the wrong...
Yes, this is what I saw on the flyer as NRM lawyer. So I don't know how he's going to correct it when he reaches there, because he's disagreeing with his boss. To get back on the question, I'm sure Councillor Barata read the ruling. This ruling was very clear, and the judge was very clear, and she stated that all the requirements have been met. And to answer your question, to arrive on the decision of a bail application, I stated that there must be two principles: presumption of innocence, two, right to apply for bail. So if someone has been remanded for long this time, and evidence, the state or the prosecution has failed to bring out the evidence, so do you want to tell me that the accused will suffer because of the failure of the state to bring out the evidence, or to bring together the evidence? Definitely no. The accused must be liberated and must get his freedom back when the prosecution fails to bring the evidence. And that's what the law says. So, to come back on that statement of the president of this country, that one also brings, or get the country into what I can call constitutional crisis. And when we get into constitutional crisis, that's why you see the illusion of democratic norms, interference of independent and government bodies, breakdown of principles of checks and balances like we have seen, increased political polarization, loss of public trust. This, for example, if you have read the police report, 1,000 cases that have been handled by police, it has been mob justice. What does it mean? Where you see the population has started taking the law into their hands, it is clear indication that the population is losing trust in the courts of law, and which means that the dignity and integrity of courts is being questioned by the population, and that is, by the way, a very dangerous point that we can reach as a nation. And also, into the political, into the constitutional crisis, we have seen the human rights violation. Human rights violation. You have seen what happened in Kawempe, how journalists were abused. These are the eyes and the ears of the country. These are the ones that come and report to this. So for that matter, I just want to put it clear that much as there is the court has discretion, there are principles that take us into the ruling.
In other words, you're saying the judge disregarded the principle of innocence that a person has until they're proven guilty. They didn't consider that at all.
I think he did not consider that.
All right.
Sorry,
Allow me, again, step into something that I think should be able to contextualize this.
I wanted to say that in defense of the judiciary, I don't think the
by the way, you don't speak for the judiciary.
The judiciary was not in Kawempe for
sure. When I was talking about constitutional crisis after the statement made by
that was a
your
footnote.
boss. Exactly.
It was a footnote in that debate. All right, here is something I need us to also rather tackle. In the ruling, she says the charges against the applicants are among the gravest, if not the gravest, on our status books. First of all, in my study of English, she seems to not be sure whether they are the gravest, or by simply saying among the gravest, if not the gravest, on our statute books. They are alleged to have been committed in various locations in Uganda and other countries, requiring more time and resources to conclude investigations than is normally the case in offenses alleged to have been committed within the country. The judge here is determining, and basically more speaking like she's a prosecutor. These offenses have been committed outside of Uganda, and
I think we must also again be careful. This matter may still go on appeal, but
based on these very reasons,
offenses have different categories naturally. A pickpocket or a person arrested for common nuisance is not considered the same or in the same category as a person accused of murder. Is not in the same category as a person accused of rape. Is not in the same category of a person accused of aggravated defilement. A person with HIV and with that knowledge gets a 3-year-old and defiles a 3-year-old. That is heinous. That is heinous, and anybody should be able to state that that is a heinous crime. So that is not the point. The point is, what is the law on bail? If bail were automatic, they would say, as soon as somebody says, please give me bail, release them. That is not what the Constitution says. The Constitution is the same Constitution that recognizes the presumption of innocence. It is the same Constitution that makes bail discretionary. Otherwise, it would have said, no, just anybody who applies for bail, just give them. No. It says, no, consider the circumstances surrounding the case, then make a determination whether or not to grant bail.
Let me hold you in your tracks there, and I apologize for that, but I have the discretion as the moderator, no doubt. If you were a lawyer, you are a lawyer, no doubt, but if you were, as in a lawyer in this particular case, and you have produced evidence to pin this particular suspect, and the judge thinks or demonstrates or suggests that maybe the evidence that you have brought forth is not enough and you might need more time. At what point does the judge determine for the prosecutor that they need more time, especially if the prosecutor has not explicitly stated that they want more time to investigate?
The arguments that you are looking at were actually made by the prosecution. The arguments that you are looking at were made by the prosecution that they are still investigating the case. This is not coming from the skies. If you actually had the real record of proceedings, you will see that those are the arguments that the prosecution made. The judge did not make any determination
after for
the prosecution.
Months.
Yes, the judge did not. Yes.
At what point?
Yes,
I must ask this question.
Yes,
does a judge say enough time has been granted for investigations in this case?
That again is based on the discretion of the judge and the evidence presented before the judge. 6 months is not much to conduct an investigation. 6 months is not much to conduct an investigation. And I'm sure you have seen cases that where investigations have been conducted with a slightly longer time frame and brought to trial and concluded. So I think we must not try and put the courts in a straitjacket. You must do this, you must do that. First of all, the court is not even the investigator. The court is not the prosecutor. Even the prosecutor is not the investigator.
The justice speaks like...
Because that is the argument that was made. The judge makes a decision based on the arguments presented and the evidence presented before them.
Interesting.
Yes.
I'm not a lawyer, and I won't probe these things further than they ought to be probed, especially in light of what the public ought to understand or know for this matter. But I would like to go back to the aspect of the president's stand on bail, because it pretty much does determine many times what certain people might do or how they might conduct certain trials. And we cannot actually claim this is not happening in the country, because when you talk matters law, there is a tendency for somebody to ask evidence, precedent, talk from a point of knowledge. But there is what the public sees, the public hears, and we've seen officers of government act as if they understand fully the sentiments, the tone, and the feelings of the president. I don't know whether that is a wayward observation to...
thank you again for that question, because it brings me back to a point of misrepresentation that was earlier made by my learned friend in reference to the statements of the president after the judgment of the Supreme Court. What the president said in that statement, and you can retrieve it and read it, he said, the judiciary does not govern the country. We all defer to the citizens. We all defer to the people, and that is in line with the Constitution, that judicial power is exercised for and on behalf of the people. It is really in line with the judicial, the provisions of the Constitution on the judiciary. Now, regarding the statements of the president on certain areas, by the way, these complaints are coming directly from the communities. If you go in the
Now let's concentrate on the president's complaints.
Yes, and that's what I'm telling you. Yeah. The president's complaints are a reflection of what you get when you go across the country. They are saying, we arrested so and so, he was taken to police, the next day we saw him on the street. We caught so and so stealing, the next day we saw him back in the village. And so the president is being responsive in that respect, and saying there are certain crimes that we should take more seriously because they affect the fundamental fabric of society. Things like murder, things like aggravated rape, aggravated defilement, those affect the fundamental fabric of society. And he says, surely you should treat these a bit more stringently
than
other offenses. And there is nothing wrong with that. In fact, that actually is in line with the usual principles on determining bail matters.
Let me ask a layman's question.
Yes.
You'll be submitting on that, but also attend to my layman's question. Has any one of us attended the trial sessions, the hearings involving Kizza Besigye and Dr. Kizza Besigye and Obed Lutale?
Yes,
Has prosecution presented some evidence with regard to the charges of treason that they face? No. Okay. So investigations are still ongoing.
The question is, has the trial started?
The trial hasn't started.
Okay, so how do you present evidence before a
So
trial has been?
right now, what has to be investigated if the trial hasn't started to allow for...
How do you investigate a matter without... How would you try a matter without investigating?
Now, you understand why this whole case is political.
What comes first? Let me clarify for you. Let me clear this confusion.
Please, please, please.
You start off with a suspicion of an offense having been committed. And it is always a suspicion because there is a presumption of innocence. That is why you hear us use the words alleged to have done. So even if you see the person there taking my phone, we will still go to court and say he allegedly to have stolen the phone. Then you investigate. The investigation is to confirm, indeed, was he stealing? Is there a good case? And once you conclude that investigation, then you come to the point of trial and prosecution. Now, the issue here in bail is you are determining what happens to this person. How do we restrict, what type of restriction of his personal liberties do we put in place while we go through this whole process? Sometimes the liberty is not restricted at all. Sometimes it is restricted in part. That is where you hear people getting cash bonds and so on and so forth. That is also some restriction, deposit your passport, etc., etc. And sometimes it is completely restricted where a person is denied bail and remanded. So there is a process, there is a flow. One thing comes before the other. You first start with the suspicion of the offense, then it's investigation, then it's prosecution.
Mr. Rashand, we are entering the final bend of this particular discussion. What next?
First and foremost,
I would let you know what is next, but also I would let you also to know what has been there.
Quickly.
You see, when state normalizes oppression, they mistakenly believe they can control resistance indefinitely. However, history has made it clear to us that no regime, no matter how repressive, can suppress a population forever. We have seen the French Revolution. We have even seen in Africa where the regime has tried to suppress the population, but it is not forever. When my colleague talked about that they arrest someone and tomorrow they see him in moving freely
on the village,
I think he forgets that even the arrest is done by the police. Police is under the what? Is under the executive. So, all illegalities, most of the illegalities you see, I think maybe if he forgets and he thinks that the police lie under the judiciary. The police doesn't lie under the judiciary. But as stated, there has been too much intimidation. There has been too much illegal activities that are done by the security apparatus. We don't know whether they get the orders from the above, as they state, but all that suppression cannot go forever. When you see that, like I talked about the Arab Spring and the French Revolution, each was preceded by a period where abnormal was made normal, which is now in Uganda. The abnormal, it has been made normal. Population was silenced. Institutions were weaponized until they felt enough is enough. And that's where Ugandans lose trust in government institutions and decide to do or to take the law in their hands, and which is very dangerous to this country. If I was the lawyer and the legal advisor of the government, I would advise the government the way it handles its things. Now it has become a military government, whereby we see now the tycoons in Uganda, now in town, they have become the military and intelligence officers. Okay, in other words, the biggest economy is being taken by what? By the military of this country. They are the ones running. All right. The economy.
We fall into another context. Allow me say it's been a pleasure having you on board this morning for the perspective regarding this particular very sensitive issue. I know there's a lot that is going on with regard to public trust in the judiciary. Well, many of you out there have your emotions and some of the reasons upon which you begin to make judgments or not. One thing I've understood from the discussion is that the law is the law and the judges are not emotional at all, as you might wish to be.
They are.
That will do it for this Kickstarter discussion, but do stay with us after the break. We shall be going to Koboko, where health partnerships between the Ministry of Health and the local governments there, including sector players like TASO, are leading health extension workers programs that will address high disease burden as well as the critical shortage of health professionals as one of the ways to improve equitable access to health services across the country. Do stay with us.